Good morning, everybody. Okay, so I'm sure you guys have all seen Savannah Marie's video about the lawsuit filed against a few people. Well, thankfully, I have a copy of it, so I'm just going to share it here with you guys, okay? So, Paparazzi Accessories is filing a lawsuit against these people, okay? It's a verified complaint. It's before Judge David Neffer, who was a professor of mine when I went to paralegal school, so that's interesting right there. Lily's getting mad at Daddy for some reason. So let's go over this complaint. Okay, so paparazzi, and they go through all the stuff. These are all the people, Melissa lives in Washington, Jerry lives in Redlands, all these people, blah, 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 blah. All right. And then they go over the jurisdiction and venue, saying this is why the court in the state of Utah has proper venue to file this lawsuit. It is filed by butchalter.com. Okay. Paparazzi business. This is the allegation part. This is the part you want to pay attention to. Paparazzi is a fashion accessory wholesaler headquartered in Utah with salespeople, consultants. No, they're customers, but they can't even be honest in their lawsuit. Operating across the United States is bringing an action against a group of former consultants who stole confidential and protected information, including information regarding other consultants, operations, finances, and other sensitive information, and publicly disclosed it, including on social media. Paparazzi is seeking an injunction and damages for breach of contract, among other things. Consultants operate as independent contractors. Consultants operate as independent customers, but that's my 2 cents. The relationship between the paparazzi and its consultants is governed by the policies and procedures, which I have done extensive blog posts on, and I've done videos on the policies and procedures, okay? Defendants Sousa, Robinette, Ferguson, Dyer, Robinson, Carroll, and Drury are each former consultants. Ex-consultant defendants is what they will be named hereafter in the complaint. And therefore, the relationship between the ex-consultant defendants and paparazzi was governed by the policies and procedures. The confidential information and non-competition agreement. Alrighty, let me pull up those policies and procedures. Give me a second to get to my desktop. Go to paparazzi, Facebook posts, policies and procedures. Just open it up. Fine, open it up in Google. Alright, so here's policies and procedures. Alright, so I'm going to do a control find. And what was the thing? Non-competition. Non-comp. Let's keep going down. Sorry, my computer made all that noise. Additionally, giving away free can lead to customers. The assumption is outlined in section. Non-paparazzi products alongside paparazzi products. Lily! It's not ball time. Apparently it is. It's ball time to her. She's like, come on, Daddy, let's go.
You are an hour and a half early.
Yeah, she is. She's more than a half hour. She's more like 2 hours early.
It's an hour and a half. It's not.
I don't see anything in here in the policy and procedures that I have a copy of saying that there's no non-competition clause. But that's just according to what I have, okay? And I'm reading this to you as we go. Certain paparazzi employees, non-independent contractors, must agree to and execute paparazzi's confidential information and non-competition agreement. Confidentiality agreement. A copy of the confidentiality agreement is attached here too as Exhibit A. Now, if I wanted to go back in and reactivate my Pacer, I totally could. I'm not going to. But they apparently attached this confidentiality agreement that either the employee signed or they had some of the top elite consultants sign. I personally never got a non-competition agreement because honestly I wasn't competing with anybody, let alone myself. All right. Defendant Sorensen is a former paparazzi employee. On August 20th, 2019, Defendant Sorensen acknowledged and executed the confidentiality agreement, evidenced by the following screenshot of the paparazzi business records. So, here's a screenshot. So, let's see. Confidentiality agreement and non-competition agreement paparazzi employees. So they had her sign a confidential. I hope she got a copy of this when she signed it. Because honestly, this is very Trumpy, okay? Just to me. When you have someone sign a NDA, non-disclosure agreement of any kind, when you're an ex-employee, no. There's a reason why people are quitting their jobs en masse. There is a reason why people aren't putting up with bullshit from their employers anymore. This is one of those reasons why. Okay? I'm just saying. This is one of those reasons why. And yes, I am having an extremely high pain day, which is why I'm wearing my Jack Skellington onesie and why I haven't done my makeup or my hair. I barely slept last night. But look what my hubby made me to make me feel better. He 3D printed me an Eiffel Tower. Because when COVID hit, we were supposed to go to Paris, and we didn't get to go. So he 3D printed me an Eiffel Tower to make me feel better. Because he's awesome. Just saying. All right, back to this. Confidential agreement states in part. So here's what her non-disclosure says. I agree at all times during the term of my employment and thereafter to hold in the strictest confidence and to not use except for the exclusive benefit of the company or to disclose to any person, firm, or entity without written authorization of an authorized officer of the company other than myself. And confidential agreement of the company. I understand that confidential information means any non-public information, including company proprietary information or trade secrets or know-how, including but not limited to research plan, research results, processing, designing, methods, compensation, employment procedures, business plans, marketing plans, products, services, suppliers, distributor, or consultant lists, or any data, and consultants, including but not limited to consultants of the company on whom I call or with whom I become acquainted during the terms of my service on behalf of the company, markets, software, specifications, invitations, operations, procedures, compilations or data, technology, designs, finances, or other business information disclosed to me by the company, either directly or indirectly, in writing, orally, or by drawings or observation. Wow. Let's cover every fucking base we can there, paparazzi. Paparazzi confidential protected information includes, but is not limited to, all information regarding consultants, operations, and finances, etc. The confidential information as known throughout the rest of this lawsuit. That's what the bolding means. So that's what they're going to reference. So like ex-distributor consultants and P&P. Section 1B of the confidentiality agreement includes, in part, the following acknowledgement. I acknowledge that during my employment with the company, I will have access to confidential information, all of which shall be made accessible to me only in strict confidence, and I authorize and disclose to paparazzi. Blah, 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 blah. Section confidentiality agreement includes in part the following provisions. I recognize the company has received and in the future will receive third parties their confidential proprietary information. And it's my duty to maintain the confidentiality of their information. So, like, upline elites, they have their name, their address, how much they make each month, what their bonuses is, what their paparazzi tree is, their generational tree. This Sorensen lady had access to all of that. So my guess is she disclosed this information to somebody, and that's why the rest of these people are named in this lawsuit, which is not nice. And I feel kind of bad for Melissa Sorensen because technically what she was doing, in my opinion, and this is my opinion, she was whistleblowing. But we know how whistleblowers are treated in this country. They're ostracized. So, yeah, she was whistleblowing, in my opinion. My obligations under this agreement shall survive the termination of my employment with the company and shall thereafter be enforceable whether or not such termination is claimed or found to be wrongful or to constitute and result of breach of any contract or any other duty owed or claimed to be owed by me or the company or any company employee, agent, or contractor. So this thing will survive for the rest of her life? Really? Okay. Section 5 of the Confidentiality Agreement. Wow, they just go over this one by one. So this one's all about if you have a violation of any of these, again, duty to maintain confidentiality and the records that are in the paparazzi corporate headquarters. So, specific performance. This is one of the reasons. The right and remedy have the duty of the confidentiality specifically enforced by any court having jurisdiction, accounting and indemnification. The right and remedy to require me to indemnify the company against any other losses. God, this is all just... See, when your corporation, when the company you're working for has you sign these non-disclosure agreements, either by DocuSign or by anything prior to you starting to work there, if you get something from your employer prior to starting, confidentiality agreement and non-competition agreement, if you are given one of these to sign, read it. Okay? Just read it. And if you don't understand it, reach out to your local law clerk office. There's a bunch of people that do pro bono work. You can always download a copy of it before you sign it, and you can go reach out to, one of the free, there's law students at every school, and I can't remember what it's called, but you can go down and get free legal services from lawsuits and paralegals. Okay, and you can have them go over it if it's, if you don't understand it, if it doesn't make sense to you. Ask them to explain it. And if your employer's like, why haven't you signed this? And you're like, because I want to know what it is that I'm signing. They can't force you to sign something without reading and understanding it. Because if they do that and you sign the document under duress, it voids the document. Because you are signing a document under duress, meaning you're signing it under protest. You're signing it because they are forcing you to. So if you get one of these documents from your employer and you don't understand what's in it and you want to get a legal interpretation of what you are signing, they legally cannot force you to sign it until you understand it, because you can just let them know, hey, I'm signing this document, but if I do so under duress, it voids the document, because Contract Law 101, there has to be a meeting of the minds. And every notary public out there and every person who understands contract law knows that the person who is signing the document has to be of sound mind. And they have to be signing that document by their own free will, without being pressured, without being bribed, without being forced. Because by doing that, it essentially voids the document. And that is the reason why when you turn 18, you can legally enter into a contract, because you are considered an adult. If you are under the age of 18 and someone gets you to sign a contract, it's void right then and there, because you are not a legal adult. You can't be held to a contract if you're not of legal age. Okay? So when they say, when Taylor Kirby came out a while ago and said, we need to go after those 18 to 25-year-olds. Yeah, because the 18 to 25-year-olds are all legal adults. And they can enter into these contracts because it's legal and it's enforceable. But if you go for someone under the age of 18, it's not legal and or enforceable. I do remember that much from my law days. All right. So, here we go. Facebook Messenger group chat. Sorry, that took a lot out of me. And I needed my Disney coffee. This is my favorite mug, by the way. I got this. It's like Disney. And it's like bumpy on the sides. It's just cool. All right. Upon information and belief, shortly after she was terminated, Sorensen became part of a Facebook Messenger group called Papa Chat United, the group chat, or on or about February 14th, 2022, Valentine's Day. Upon information and belief, the group chat was organized by an ex-consultant defendant for the express purpose of organizing efforts to harass and harm paparazzi. Upon information and belief, all of the defendants are individually participating in a group chat over the course of several months. Okay, this is the reason why I don't go on social media very much, and if I do, I just point out logic. But I don't participate a lot in the groups. I'm in a lot of former paparazzi groups, but honestly, like I said in the Crack the Crown video where, that group disbanded, I was spending too much time in that group and it became extremely toxic and culty to me. And I was like, I'm getting way too wrapped up in this. So I backed away from it. And I've been kind of silent on Facebook. I don't post a lot. For one, I'm not a big social media person on Facebook or Instagram anymore. I don't have a lot of energy, which is why I focus my energy on putting out these videos for you guys. That's it. That's where my energy is focused. All right. Upon information and belief, the defendants individually participated in a group chat over the course of several months. Upon information and belief, the group chat was used as a means for ex-consultant defendants to communicate with Sorensen about stealing confidential paparazzi documents and information, including information of which is defined in confidential information pursuant to the Confidentiality Agreement. Recently, paparazzi obtained access to the certain messages exchanged by the defendants in the group chat. Again, cover your ass, people. On February 24th, 2022, Sorensen sent a message in the group chat explaining that she was fired. Paparazzi shut down her lines of business communication, including access to the paparazzi databases, company email, and other paparazzi owned and controlled programs and information. So, again, this woman was being a whistleblower, in my opinion. Paparazzi caught wind of it and fired her butt. And then they sued her. Despite acknowledging that paparazzi has clearly revoked her access to its databases, Sorensen explained that she had improperly retained access to corporate administration account, which had not been shut down following Sorensen's termination, the paparazzi admin account. All right, so why is this her fault? Paparazzi clearly doesn't have their shit together because they didn't realize this when they fired her? Yeah, it just goes to show that this corporation is run by a bunch of idiots. Okay, that's my opinion. I'm going to keep saying that this is all my opinion. My commentary is my opinion on this. Sorensen reported in the group chat. David's just blowing his nose.
Excuse me.
Sorensen reported in the group chat that she could log into paparazzi's confidential databases through the paparazzi admin account. Upon learning of Sorensen's improper and illegal access to the admin account, ex-consultant defendants conspired, encouraged, and worked with her to use some of this improperly retained login information to access this confidential information. For example, Souza directly asked Sorensen, "With your sign-in, is there anything you think we can get before they lock you out?" Souza also asked Sorensen, "On the access that you have, there isn't any way you can tell how many active consultants there are." From these messages and others, it's clear that Souza and other ex-consultant defendants wanted to get their hands on as much confidential information as they could through Sorensen's unauthorized access to the paparazzi admin account. After further investigation, Sorensen reported that in the group chat, she could access any paparazzi docs they put out for consultants, as well as current consultant accounts, including, well, everything on the account, new releases they will be putting out for the day. In an effort to protect herself and her co-conspirators, Sorensen explained in the group chat that she would spoof her IP address and use a VPN to avoid getting caught by paparazzi. Clearly, Sorensen and the ex-consultant defendants knew their access of the confidential information was improper and illegal. Wanting to provide even more assistance, Sorensen said she would see if she could find out other confidential information from someone who still works there. She has access to the info, and Sorensen could randomly bring it up somehow. Alright, so if you still work at Paparazzi Corporate and you're friends with Melissa Sorensen, you could essentially, by just talking to her, and this is another thing corporate America seems to think they can do, is they can look at your cell phone communication, your private cell phone that you pay for, that they don't, they can compel you to show you who you're talking to. And if they find that you're talking to Melissa Sorensen, could they have grounds for termination for you? I mean, I wouldn't expect paparazzi to stoop that low, but yeah, I would, actually.
Well, if it's a at-will state, they can get rid of for members.
That's true, and Utah is an at-will employment state, so they can think of any excuse to terminate your employment. They don't have to give real justified reason and or cause. It's at-will. That's something the lovely Republican-run state has done. If your state is an at-will employer and they, they can fire you for any reason, look at it in reverse. You're an at-will employee as well. You don't have to give them reason for quitting. You don't have to give them notice for quitting. You don't even have to sign anything when you quit, which is what they compelled these people to do with these non-disclosure agreements. Okay? So you're an at-will employer. Your at-will employer can ask you to sign this shit, but as an at-will employee, what are they going to do? Honestly. All right. Okay, back to this. Sorensen then accessed, was I on 41? Yes, I was on 41, sorry. Ex-consultant defendants conspired with Sorensen to access confidential information regarding numerous activities of paparazzi consultants. Sorensen then accessed, downloaded, and shared vast amount of this confidential information with the ex-consultant defendants in the group chat, including a total number of paparazzi consultants, customers, consultant profiles, and active consultants that she stole from paparazzi's computer database. Upon information and belief, Sorensen accessed and shared paparazzi's financial data and information, including the information relating to the sales and commission reports. Sorensen shared information regarding paparazzi's business operations and processes, including operations relating to some of paparazzi's active consultants. Upon information and belief, Sorensen shared multiple iPhone screen recordings with ex-consultant defendants in the group chat that disclosed paparazzi's confidential information. Upon information and belief, Sorensen also emailed large files to ex-consultant defendants. The large files attached to these emails contained confidential information, including commission totals for many active consultants. Upon information and belief, Sorensen and the ex-consultant defendants shared the confidential information that Sorensen accessed, downloaded, and disclosed with other people. This lawsuit was filed on April 25th. The complaint was filed April 25th. I'm guessing that is why the United Break the Chains Facebook group has pretty much gone silent, is because of this lawsuit. They have gone silent because they've probably been advised by their attorneys to do so. All right. Sorensen and the ex-consultant defendants did so try to harm and disrupt the paparazzi business, including, for example, its operations, its contractual relationships with its consultants. Obviously, paparazzi never authorized nor permitted the defendants improper and illegal access to the information, and paparazzi never authorized or permitted the defendants to share the information on the internet. At all times, defendants acted in secret in such a way to prevent paparazzi from learning about their unlawful actions. I really don't think it was done in secret, but whatever floats your boat, Butch Alter, that's fine. In fact, at one point, the group chat Sorensen even asked just to make sure no one is ever going to know where these came from, correct? Like, no one will ever know how they were obtained. And Carol responded, never. All right. First claim for relief. Paparazzi realleges and incorporates by reference allegations in the preceding paragraph. Sorensen signed and agreed to abide by the confidentiality agreement contained in the following language. So they go over the confidentiality agreement again. They say that Sorensen breached it. As a result of the breach, the company has been damaged. And as to ex-consultant defendants, their intentional inference with the paparazzi economic relationship. Second claim for relief, breach of contract, because they made her sign that contract. I hope she has a good attorney that looks at how she signed this non-disclosure agreement, when she signed it, what was her frame of mind when she signed it, because honestly, if it was signed without even being read, or if she even understood what she was signing and it was all done by DocuSign, and she didn't get a copy of it, I'm just saying. I'm just saying. And let me bring this forward. I can't. I just can't. It makes me sad, okay? Paparazzi performed under the confidentiality agreement by providing employment and pay to Sorensen. Yeah, I bet it wasn't even minimum wage, because in Washington, Utah, even though it's extremely expensive to live there, I doubt they paid her even $15 an hour, to be honest. Just saying. By its express terms, the obligations pursuant to the confidentiality agreement survive her termination. Again, very Trumpy. To get those NDAs signed and then try to enforce them through lawsuits. God, I fucking hate this. Sorensen has breached the confidentiality agreement by accessing and disseminating paparazzi's confidential information. As a result, the breach of the confidentiality agreement, paparazzi suffered damages, including lost business and its reasonable attorney's fees and costs incurred herein. I call bullshit paparazzi, and here is why. Lost business. You held a convention called Celebrate 2021 in Las Vegas. What took place at that convention was people were not properly social distancing. They were not wearing their masks. I'm pretty sure a good portion of your consultants were not properly vaccinated. You held a super spreader event. And when people came home and 20 plus consultants died as a result of this convention, it angered a lot of people. And a lot of people left your company because, one, you didn't acknowledge their deaths. Two, you scrubbed them from your website and then told everyone not to talk about it and to be quiet. So your lost business came from your lack of acknowledgement of the people who died at your convention. Then, on December 16th, 2021, you silently scrubbed from your website the claims that the company is lead and nickel free. That your jewelry is lead and nickel free. Okay? You, paparazzi, silently remove those claims from your website. You were like, ooh, it's about us. So here's the day that the stuff was gone. This is December 16th. And that's what I found when I put that in. So let's look at the next one. Here it is. There it is without my face. All right. And then where's the one? Here it is right before, from the Wayback Machine. Lead and nickel free, one of a kind, style, design, original, blah, 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 blah. But it's lead nickel free. But on December 16th, you decided, yeah, we're done. We're not doing that anymore. Yeah. Just saying. Your lost business is because of your improper conduct, not because people are sharing confidential information. People are leaving paparazzi because the claims of the jewelry being lead and nickel free is no longer a valid claim. That was one of the reasons why I signed up to sell this shit. And I found out it wasn't. Okay, third claim for relief. Paparazzi realleges the preceding paragraphs, confidentiality agreement by Sorensen, breach of good faith. They want to go after lost business, reasonable attorney's fees, and costs. So they're basically just repeating, enforcing the confidentiality agreement. So they've done the non-disclosure and then the confidentiality. Fourth claim for relief, international interference with economic advantage, all defendants. Paparazzi realleges the incorporations by reference, including the preceding paragraphs. Defendants have intentionally inferred with paparazzi's existing and prospective clients and consultants. Pretty much every anti-MLMer out there is just pointing out the bullshit. We're not going out there and telling people not to, telling people to cancel. We're encouraging people to look into all the information before they sign up and give this company their money. And I will constantly harp at people, when you are a consultant, you are a customer. Because they wouldn't sell this crap otherwise in the bulk quantities that they sell it at on a Monday through Friday daily basis at 12 noon, because their customers won't go in there and buy 50 of one piece at one time. Okay? It's just the truth. It is the truth. Come back to me, camera. Focus on Jack. I hate it when it does that. Okay. Defendant's interference was for the improper purpose of injuring paparazzi and its business. We're not trying to injure paparazzi. We're trying to point out that all MLMs are deceptive and predatory. All of them. Not just paparazzi. All of them. And the only reason I speak out against paparazzi is because of my personal involvement. I was a consultant. I never recruited anybody, but I put myself in a lot of debt and made myself sick. Okay? Defendant's interference was done through improper means, and their interference violates settled common law and involved intentionally deceitful acts to I don't know what that word is, and use and disclose paparazzi's confidential information. The defendant's acts were also contrary to established standards in the industry, as evidenced by paparazzi use of the confidentiality agreement. As a result, defendant's improper interference, paparazzi has been and will continue to be damaged, including lost business, reasonable attorney's fees, and costs. Civil conspiracy is the fifth claim. They have 5 claims for relief. This is insane. Maybe more. Oh, they have 6. They have 6 claims for relief. Fuck me. Paparazzi realleges and incorporates by reference the allegations in the preceding paragraphs. Defendants discussed, conspired, and determined to violate their agreements with paparazzi, improperly accessing, stealing, and using and disclosing paparazzi's confidential information. Defendants then actually illegally accessed paparazzi's secure database, stole information from the database, and used it to disclose information for the sole purpose of injury. As a direct result, the defendant's conspiracy and unlawful acts, paparazzi has been and will continue to be damaged, including lost business, reasonable attorney's fees, and costs. Paparazzi realleges and incorporates by reference the allegations in the preceding paragraphs. Sorensen knowingly and intentionally accessed paparazzi's computer network by her admin account despite her knowledge that she did not have authorization. She knew she didn't have authorization, but you, paparazzi, didn't shut the admin account down. So, that's negligence on your part, paparazzi, because you terminated somebody, but then you didn't shut down her access at all. So, that's negligence on your part, and your failure to recognize that this was going on it's just pure negligence. I'm sorry. Sorensen knowingly and intentionally obtained confidential information from paparazzi's network. Sorensen's access resulted in a loss of paparazzi's confidential information. As a result, paparazzi has been damaged and suffered loss. Wherefore, paparazzi requests the following relief. For injunctive relief, both preliminary and permanent injunctive relief as a result of the improper use, access, and disclosure. For awards of damages against Sorensen for breach of contract and the breach of the implied covenant of good faith and fair dealing in the amount of to be proven at trial. All right. The doctrine of unclean hands. Paparazzi has been doing business in bad faith and unfair dealings. So the doctrine of unclean hands kind of comes into play here. Because if you're going to say that she did something under the implied covenant of good faith and fair dealings, what are you doing, paparazzi, under good faith and fair dealings? Because as far as I'm concerned, paparazzi, you have acted in bad faith, deceptive practices, and unfair dealings. That's my opinion. And it stems from the day you took your lead nickel free claims down and didn't tell anybody about it until 3 days later. You sent out an email to everybody saying, our product is still Prop 65 compliant, but we're not going to claim it's lead nickel free anymore because it's clearly not free of those items. And then you stopped selling Starlit Shimmer because it wasn't Prop 65 compliant. And even in your books that you send in your starter kits, you advertise Starlit Shimmer to children. So, where's your clean hands, paparazzi? Because as far as I'm concerned, doctrine of unclean hands really comes into play here. Just my opinion. I'm not an attorney. I went to school for paralegal studies. I was really big into contract law. I was a realtor. The knowledge I retained from all my classes is still in my brain. But my comments are all my opinion and not coming from any legal standpoint. For awards and damages against the defendants for intentional interference with economic advantage in an amount to be proven at trial. So they want to go to trial. For awards and damages against defendants for civil conspiracy in the amount to be proven at trial. For awards and damages against Sorensen for violation of the Federal Fraud and Computer Abuse Act to be proven at trial. For punitive damages, for attorney's fees and costs, and for other such further release that the court may deem just and proper. God, I wish I lived in Utah right now, because here's the deal. If they had a jury trial, I would so. Oh, and Chantel Reeve, Shani, is the one who signed the lawsuit. Wow. So there's that. So I'm going to get this posted because I know there's a lot of curious people out there that want to see what this is about. So I'm not going to do Papa Crappy today, but here's the lawsuits filed by Butch Alter in Salt Lake City, Utah. They also have offices in California, I believe. But they are the paparazzi attorneys, and the reason I know this is because of the cease and desist I got from Butch Alter. But it's really sad that they've even got John and Jane Doe 1 through 10, so they are hoping to add more people to this lawsuit. So, paparazzi's hands aren't clean in this, and paparazzi, honestly, if you signed a non-disclosure agreement with your employer, and my guess is that you signed it without reading it, and you may have signed it under duress. You had to sign it on the 9th. Yeah, my guess is they created this, sent it to you, so you can accept your employment contract, because of the at-will employee. But you signed it on the same day you received it. And honestly, if your employer sends you one of these documents to be signed prior to your employment, don't sign it until you've had a chance to actually read it. Because these are the kind of things that corporate America will hold you to and make you accountable to, and it keeps their hands clean. So the takeaway from this video is, if you are employed by a company and they have you sign one of these bullshit agreements, know what you're signing before you sign it. All right. Have a great day, everyone. Thanks for listening to this 40-minute video, and I'll catch you later.